Hello class and welcome to the Week 2 lecture for Introduction to Law. This week we will start with a discussion of the differences between substantive and procedural issues in the law. The first distinction that I want to discuss with you is the difference between civil and criminal law. Civil law governs the issues that arise between parties over private rights. A civil case is brought by the injured party for damage to his or her personal rights, person, or property. The injured party seeks some sort of compensation, usually monetary, for the injury or damage to the person or property. One aspect of this area of law, for example, is torts, which we will discuss in Week 4. The second area of law is criminal law. This is brought by the government for the violation or injury to public rights. An individual who violates these laws violates the rights of the public as a whole. Criminal law carries a penalty of fine, imprisonment, or community service that is paid to the government rather than to a particular victim. A court may also order restitution or compensation to the victim. Civil cases are brought for a violation, as mentioned above, for private personal rights, including physical, emotional, financial, and property damage. Remedy is usually monetary for the individual whose rights were invaded and injured. In cases where money cannot adequately compensate, but some action could, the guilty party may be ordered to act or refrain from acting in a certain way. This is called injunctive relief, and more particularly, specific performance. This type of relief is quite limited. Some jurisdictions also permit the recovery of punitive damages, also known as exemplary damages, which are additional monies that the defendant is ordered to pay as a form of punishment. The reasoning behind punitive damages is that some actions are so grossly improper that the defendant should be punished in a way that will serve as an example to others who might contemplate the same wrongful conduct. In civil cases, procedural law takes effect when citizens bring a dispute to the legal system. In criminal law, the law enforcement agencies and prosecutors who are part of the legal system initiate a claim against the citizen. Continuing on, it's time to discuss the most important distinction that we will be talking about this week, the difference between substantive and procedural law. Substantive law, as seen on the slide here, creates, defines, and regulates rights as opposed to protective, procedural, or remedial law, which provides a method of enforcing rights. And procedural law prescribes a method of enforcing rights or of obtaining redress for the invasion of rights. The basic function of civil procedural law is to facilitate the movement of a lawsuit through the legal system. And procedural laws are created to ensure that each party will be afforded fair and impartial treatment. The goal of procedural law is that judges and juries receive only evidence that will allow them to make a fair and impartial decision. And it plays an important part in litigation, including the following: the time limit for bringing lawsuits, known as statute of limitations, the manner in which lawsuit is began, that is by filing the complaint or petition, the proper way to inform the defendant that a lawsuit has been filed, the types of information that each party must release to the other party, the procedure at trial, the evidence that can be introduced at trial, and the method for appealing the decision if the losing party feels the decision was unfair. And we discussed how that appellate process works a little bit last week. It's important to note that sometimes there can be a conflict between laws, as in a case where citizens from different states are suing each other. And where there is such a conflict of law, i.e. different standards apply in different states, or more than one jurisdiction has contact with the dispute, there's potential for procedural law to affect the outcome of the suit rather than substantive law. And the general rule is that a court should always attempt to apply its own procedural laws regardless of which substantive law applies. You may ask, how are these laws governing procedure created? They are created by the authority of the legislature. In many jurisdictions, the legislatures vest the courts with the authority to create such laws. At the very least, the courts have input into what the procedural law should be. This is actually how it works in the federal system, where the federal rules of civil procedure are created by court-appointed bodies. Moving on, but jurisdictions often divide the procedural law into various categories. These categories are the rules of civil procedure, the rules of criminal procedure, rules of evidence, rules of appellate procedure, and local rules. The rules of civil procedure include the laws that dictate how a suit will be filed, all pretrial matters, trial proceedings, with the possible exception of rules of evidence, and post-trial issues until the case is concluded or the appeal is initiated. An action or lawsuit is filed by the plaintiff who presents a complaint or petition, which is a document alleging what the defendant did that was legally wrong, with appropriate filing fees, costs of processing the documents, to the court of the clerk. And an exception would be a request for an emergency order. It's important to note that this procedure is very important, and in fact, it will be the basis for one of your assignments. Traditionally, a complaint sought monetary damages, and a petition sought some sort of equitable relief, such as the distribution of assets in a fair manner or specific court-ordered conduct by the defendant for the benefit of the plaintiff, as in the case where, for example, an injunction or specific performance is sought. Preservation of the terms complaint for chancery-type actions and petition for actions based on equity persist, but realistically, these days, some blending has taken place, and in fact, the federal rules of civil procedure make clear that there really isn't much of a difference, at least in what procedural rules apply between whether or not you're seeking equitable relief or money damages. Moving through these pretrial proceeding phase, the complaint is organized into what are usually single statements, numbered and referred to as paragraphs. Each statement is a statement either of existing law or a statement of facts the plaintiff alleges that have occurred, and when read in its entirety, the complaint should state which laws have been allegedly breached and the facts that state how the law was allegedly broken. In addition, the complaint will indicate what compensation is necessary to satisfy the plaintiff's injuries. The next document we will discuss is a summons, which is the formal legal notice of suit. It is issued to the defendant in the lawsuit and is usually accompanied by a copy of the complaint. A summons indicates how long a party has to respond to the claims of complaint. And methods of service of this summons and complaint vary by jurisdiction. And legislatures are very slowly responded to changes in technology that make it much easier to ensure that defendants get proper notice of the suit. It's important to note that if the defendant does not respond to the complaint with the allowed time period, the court will accept everything alleged in the complaint as true and grant a decision in favor of the plaintiff. This is known as a default judgment. You should never ignore an order of the court. And the basic methods of responding to the complaint are the same. You can give an answer. The defendant responds to each item specifically alleged in the complaint with an admission, denial, or by pleading an inability to admit or deny based on a lack of information. You can also file for a motion for a bill of particulars or a motion to make more definite or certain, which is a claim that the complaint as stated cannot be answered, or a motion to dismiss or a demurrer. The complaint either does not contain facts that warrant any type of lawsuit or the complaint is improperly stated according to procedural rules. Sometimes these are blended together. In every lawsuit must be done so under a recognized cause of action with specific elements that must be proven. Future weeks of the course will discuss different types of causes of actions and the elements that must be proven. Moving forward, we should talk about discovery, which is a process which, under procedural rules and court supervision, the parties exchange information. The goal of discovery is to foster the fair exchange of information to enable the parties to clearly evaluate their positions and evaluate settlement possibilities. There are many methods of obtaining information. One is interrogatories, which are written questions submitted to the opposing party in the case and answered under oath. You can do a request for production, which is a request for the defendant to produce documents, copies of documents. You can do depositions, which you ask people to appear, and the attorneys ask a party or witness questions about his or her knowledge of the case. They are usually taken in person and in the presence of attorneys for each party, and the entire proceeding is recorded by one who is also a notary public and asks the person deposed to tell the truth. The next issue that we should discuss in connection to pretrial proceedings is motion practice. A motion is a request by an attorney whose party seeks assistance or a ruling from a court on a particular issue between the parties. These comes in various forms. They can include things such as a motion to dismiss, which is when a party believes the facts of the case do not support a viable cause of action and therefore get a judge to summarily dismiss it. You can get a motion to expect. or a motion for a mental or physical exam, where you can request that a doctor or psychiatric professional examine a party. You can get a motion for sanctions. This can be used during discovery at any time during the proceedings when one party is of the opinion that the other is willfully disregarding the rules of procedure or orders of the court. And you can do a motion for summary judgment, which is among the most important motions made in trials. And the basis of this motion is that the evidence is so overwhelmingly in favor of one party that no reasonable judge or jury can find in favor of the other party. Consequently, the party seeking the motion contends that there is no basis for trial and the case should be determined without trial and in favor of the requesting party. And when this motion is made, the judge must make a serious evaluation of the evidence. If the evidence is so strongly in favor of a party that a jury can only reasonably reach one decision, and there is no substantial question to be left to be determined regarding the facts that occurred, then a motion for summary judgment may be granted. It's important to note from all of these things that all of these things require a significant investment in time on the part of attorneys and paralegals, and therefore they also require a significant outlay of money on clients, as typically paralegals and other lawyers and legal professionals bill by the hour. So doing one of these trials, discovery especially, but also this motion practice, requires a significant